So I'd like to share with you guys something that's been heavy on my mind for about 30 years. This is a far takeoff from the normal content of my channel. This has to do with you, me, and everybody, as it involves civil rights as a whole. And the individuals of the United States are guaranteed the certain protection of civil rights, and that doesn't always happen. When that doesn't happen, we have some serious issues with our system. And my life has been no different to these serious issues with our system as a lot of people's out there have been. But I'm going to share my personal story. The government's probably going to attempt to censor it, but they can frankly kiss my ass because they're the corrupt ones here. So, this is 18 U.S. Code 222, deprivations of rights under color of law. Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, penalties on account of such person being an alien or by reason of his color or race, then are prescribed for the punishment of citizens shall be fined under this title or in prison not more than 1 year. Okay, this defines 1 year imprisonment. It also goes on to define if death results or kidnapping or aggravated sexual or abuse or attempt to kill can substantially increase this prison time from 1 year to life, and in some cases sentenced to death. So the deprivation of one's civil rights is not a laughing matter, I would say. 18 USC 1201, kidnapping. Whoever unlawfully seizes, confines, inveigles, decoys, kidnaps, abducts, or carries away and holds for ransom or reward, or otherwise any person except in the case of a minor by the parent thereof, when the person is willfully transported in interstate or foreign commerce, regardless of whether the person was alive when transported across state boundaries, or the offender travels in interstate or forest commerce, uses the mail means or any means, facility, or instrument of interstate or foreign commerce in communicating or in furtherance of the commission of the offense, blah, 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 blah. Any such acts against person is done with special maritime and territorial jurisdiction of the United States. Okay, so with that being said, that's what the federal government feels about these laws. I'm going to share these papers. I will read them. If you'd like to pause and read them yourself, you are more than welcome. I'm going to just run through these. I'm going to start with the exhibits. It'll help catch everybody up with where I'm coming from before I actually start reading the laws that apply. Okay, so this is what we're going to call Exhibit Number 1. This is from the state of Montana, 21st Judicial District. The judge presiding was Jeffrey H. Langton. Counsel appearing, Gerald D. Williams and J.D. Shockley. J.D. Shockley later became the ethics chairman of the state of Montana. He was also on a drunk driving committee and found to be drunken driving. Not unusual. Jeffrey H. Langton has a long history of drinking, being passed out in public. Just a general nasty character in a position of trust. Title of this cause, Juvenile Matter. That right there is my name. My name is Sean Ryan Cowan. Now I'm going to read through this. This cause came regularly on or before the court this day on summons. The youth was present with counsel, Mr. Williams. Representing the state, also present was the youth's mother. Discussions heard in regard to conflicts of interest with the court and Mr. Williams. The youth's mother stated that she would request another prosecuting attorney for this matter. Discussion heard in regards to the youth's father, blah, 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 blah. This is all impertinent to my case at the moment. Contempt of court. Advise him that if he does not appear for the OSC, a warrant, blah, blah. The court advised that the youth, second petition, and the allegations contained therein. The youth waived the reading of the second petition. The court advised the youth of his rights. Mr. Shockley requested additional time prior to the entry of admissions or denials. Judge Langton advised counsel that he cannot set an arraignment date for this matter and shall leave it open so as to allow the judge who assumes this matter to set the schedule. Any defense, since they were requested any time between now and the arraignment date is attributed to the defense, since they requested the disqualification. Mr. Demons, blah, 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 blah. Nothing on that page is pertinent. This talks about me being released with reprimand from the court. And then it comes down here. The court retained jurisdiction in regard to the contempt matter for the youth's father. The court directed that the OSC hearing be set for Wednesday, January 19th, 1994. Okay, and then pretty much immediately after this happened, Judge Jeffrey H. Langton went on back to his chambers. He filed an invitation to assume jurisdiction. The undersigned hereby withdraws from jurisdiction and invites the Honorable Frank M. Davis to assume jurisdiction over the above captioned cause. Dated 29th day of December. Filed in court June 4th, 94. Okay, so the judge has acknowledged he has a conflict of interest. He put it down in paper, signed it, and walked off the case. This conflict of interest, well, it'll be going into further on here. The next issue that I'd like to address, that is me. Excuse me. The Supreme Court for the state of Montana petition for writ of supervisory control. All right. Comes now the petitioner, Sean Ryan Cowan, pro se, pleading this court for a writ of supervisory control to correct unconstitutional actions that are preparing to harm the petitioner and his immediate family. All actions contained herein happen in the 21st Judicial District, previously known as the 4th Judicial District. Cases involved, child support. I'm not going to read all that. If you want to read it, you can. It will break it down more thoroughly throughout the documents. Okay, authority of court. There is legal sufficiency to show plaintiff is entitled to relief under his complaint. A complaint should not be dismissed for failure to state claim unless it appears beyond a doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Conley versus Gibson. However you say that, versus Williams. And then it keeps going. Rule 12b-6 does not countenance dismissals based on a judge's disbelief of a complaint's factual allegations. In applying the Conley standard, the court will accept the truth of a well-pleaded factual allegations of the complaint. All right, this is a Montana Law MC. This actually might be Montana Rules of Civil Procedure. Supervisory control. The Supreme Court has the supervisory control over all other courts and may, on a case-by-case basis, supervise another court by way of a writ of supervisory control. Supervisory control is an extraordinary remedy and is sometimes justified when the urgency or emergency factors exist, making the normal appeal process inadequate. When the case involves purely legal questions, and when one or more of the following circumstances exist. A. The other court is proceeding under a mistake of law and is causing a gross injustice. B. Constitutional issues of a statewide importance are involved. Alright, proceeding pro se. Pleadings in this case are being filed by plaintiff, wherein pleadings are to be construed without regard to technicalities. Pleadings are not to be held to the same high standards of perfection as practicing lawyers. See Haynes versus Kearney. Also see Powers. 11th Circuit. Also see Holsey versus Owens. 5th Circuit. Also see Hall versus Belmont. 10th Circuit. In Puckett versus Cox, it was also held that non-lawyer pleadings require less stringent reading than one drafted by a lawyer. 6th Circuit USC, Justice Black in Conley versus Gibson. 1957, the federal rules rejects the approach that pleading is a game of skill in which one must step by counsel may be decisive to the outcome and to the acceptance of the principle that the purpose of pleadings is to facilitate a proper decision on the merits. Accordingly, Rule 8F, Federal Rules of Civil Procedure, and the State Court Rule, which is Montana State, holds that all pleadings shall be construed to do substantial justice. Okay, now we're going to get into the background a little bit. Sorry about that, excuse me. Alright, the petitioner, Sean Ryan Cowan, has been in the criminal justice system on and off for 26 years, starting at age of 11. All judicial action was brought against him by the 21st Judicial District of Ravalli County, Montana, before Jeffrey H. Langton. Petitioner has discharged all judicial sentences several years ago and has been a law-abiding citizen with most rights restored. He is currently involved in a dissolution of marriage in the 21st Judicial District of Ravalli County, cause DR 19-177. The court has ordered a guardian ad litem to present opinion for best interest of the child. Petitioner's son. This guardian ad litem / agent of the state is to be paid for by the parties involved in the dissolution of marriage. Its duties will involve investigating the petitioner and writing an opinion regarding the petitioner to decide his parental rights over his son. The petitioner refuses to pay for this service until the 21st Judicial District address some constitutional discrepancies that appear in the petitioner's past criminal records. I will try to explain to the best of my ability. These issues didn't appear from thin air. They are the byproduct of several cases. DR 182 or DR 82-162, Child Support Amendment Proceeding. This case involved the natural parents of petitioner Joyce S. Cowan, mother represented by attorney Jeffrey H. Langton versus Arden R. Cowan, father represented by Gerald D. Williams. These actors were involved in this case on or about 1988-89. Debt for legal services incurred during this case were owed to Jeffrey H. Langton until 1998, 10 years, by Joyce S. Cowan, according to financial records. I do not currently have records, but it is my understanding that Arden R. Cowan was also in debt to Gerald D. Williams for his legal services. In this case, Jeffrey H. Langton discussed that petitioner suffers from developmental disabilities. For info on this case, I have to rely on information inferred by the record. Alright, DJ 9201, Youth Court. Judicial hearings were initiated by Gerald D. Williams, acting as Ravalli County Deputy Attorney, bringing this action for the state, and Jeffrey H. Langton, Judge, presiding for the state. This cause involved two petitions alleging the youth delinquent. The first petition, a consent decree, was entered and successfully discharged on or about June 15th, 1993, signed off on by Jeffrey H. Langton. A second petition alleging the petitioner, a delinquent youth, was filed a short time later in the same cause, DJ 9201, by the same actors, Langton and Williams. On or about December 29th, 1993, Joyce Cowan started questioning if a conflict existed. See minutes entry attached. We've already gone over the minutes entry. That is where it discussed the court, or the judge and the prosecutor being removed from duty in the middle of a hearing for conflict of interest. Promptly, both judge and deputy county attorney were disqualified from the court proceeding they initiated. When this happens, I would say that is very much a mistrial, and all charges should have been dismissed. It appears that Judge Jeffrey H. Langton, according to personal records of Joyce Cowan, had a pecuniary interest that he failed to disclose at the origin of the judicial proceedings against the petitioner. As a minor child, the conflicting interests went undisclosed until the petitioner's mother addressed them. Only then did Jeffrey H. Langton and Gerald D. Williams acknowledge the disqualification. Petitioner has no evidence this disqualification was ever referred to the Montana Supreme Court for reassignment of judge. Oh, and I got a wicked itch. Alright, so now we're going to go into some Montana Code Annotated. It'd be section 31508. Whenever a party to any proceeding, any court shall file an affidavit alleging facts showing personal bias or prejudice of the presiding judge, such judge shall proceed no further in the cause. If the affidavit is filed against a district judge, the matter shall be referred to the Montana Supreme Court. If the affidavit is in compliance with subsections A, B, and C below, the Chief Justice shall assign a district judge to hear the matter. Judge was disqualified. It was never reported. So obviously, Montana Supreme Court didn't assign a new judge. The judge who disqualified himself did. On December 29th, 1993, Judge Jeffrey H. Langton signed his disqualification. See attached minutes entry. Indicates of unknown pre-existing factors involving petitioner's natural parents, dissolving Judge Langton from jurisdiction, where he then deposited a copy in the record of DJ 9201. That copy we've already gone over. That was his acknowledgement of jurisdictional defects and invitation to assume jurisdiction, which I find was done outside of Montana state law. We're going to fast forward 8 years. DCO 211 and DCO 854. DCO 211 would actually be fast forwarding 8 years. DCO 854 would be fast forwarding plus 6 more years. So we're going to say 14 years or so. These were both adjudicated by Judge Jeffrey H. Langton after his on-the-record DJ 9201 disqualification of jurisdiction. During sentencing of the DCO 211, Judge Langton and the Ravalli County Attorney discussed DJ 9201, the same case Judge Langton's disqualification appears in. The petitioner believes his 6th, 13th, 14th Amendment right were deprived and received no right to a fair trial in front of an impartial judge. The petitioner has since attempted to assert his legal challenge for equal protection of the law and has so far been denied on every front. Okay, the right to a fair trial. I don't think we need to discuss this. I mean, this goes as far back as 1215 into the Magna Carta, which is actually what Montana law was established off of. Regardless, the first 10, we're going to call them commandments of the Bill of Rights, were all also established from the Magna Carta. So that is, remember, we're talking 800 years of history here where individuals have right to a fair trial in front of an impartial judge. Okay, so the well-established common law rule that recusal is required when a judge has a direct, personal, or substantial or pecuniary interest in a case. In Montana, such matters are addressed and governed by the 2008 Montana Code of Judicial Conduct. And because the Code of Judicial Conduct provides more protection than due process requires, most disputes over disqualification will be confined to rare instances. Montana's Code of Judicial Conduct, Rule 212, requires that a judge disqualify himself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. 1, the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of the facts that are in dispute in the proceeding. A judge shall also disqualify himself if the judge served as a lawyer in the matter in controversy. This is Bowman versus State, Montana Supreme Court laws. April 20th, 2021. I recently attempted to attack these judgments twice in our Valley County 21st Judicial District. First attempt through a motion to vacate filed in both DCO 211 and DCO 854 causes that were dismissed by order summarily denying my motions only 2 days after they were filed. This appears to be an exhaustion of state judicial remedies. All right, summarily denying. That is, you lost, you have no appeal, we do not want to hear from you, we do not want to address it. That's pretty much a judge abusing his discretion right there. The second attempt on or about May 3rd, 2021 was through a collateral attack involving dissolution of marriage. In this dissolution, I am ordered to pay for a guardian ad litem to review my past. I admit I have a problem providing money to a state agent to decide the best interest of my child by reviewing documents of questionable constitutional construction in order to form the opinion that decides these rights. This court also denied my motion to vacate on grounds that I was to file under the cause DCO 211 and DCO 854. Right there. I completed that in my first attempt, April 20th, 2021. Alright, so Montana law, there's more about guardian ad litem, but this is the part that pertains. 44205, guardian ad litem. The guardian ad litem has access to court, medical, psychological, law enforcement, social services, school records pertaining to the child and the child's siblings and parents or caretakers. It appears I have been deprived of my 6th, 13th, 14th Amendment and various other rights by Montana state authorities, which have led to the insertion of multiple judgments which appear void on their face for blatant jurisdictional defects. I have to contest when a state court asks me to pay for someone to access these judgments to determine if I get to continue creating a meaningful bond with my son. The issues I assert about these judgments that appear void on their face is not a discretionary issue in the eyes of the federal courts. Now we're moving up to SCOTUS at Supreme Court of the United States law. Since the trial court's dismissal with prejudice was void, it may be attacked either by direct appeal or collateral attacks. Ex parte Williams. A void judgment is a nullity from the beginning and is attended by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Ex parte Spalding, blah, 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 blah. T concurring. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. A void judgment, which includes a judgment entered by a court which lacks jurisdiction over the parties or of the subject matter, or lacks inherent power to enter the particular judgment, or an order procured by fraud, can be attacked at any time in any court, either directly or collaterally, provided that the party is properly before the court. See Long versus Shorebank Development Corporation, blah, 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 blah. Alright, a void judgment is a nullity from the beginning and is affected by none of the consequences of a valid judgment. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. Under federal law, which is applicable to all states, the United States Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Alright, so if you don't know what in law as trespassers do, you need to research that. Trespass is a tort law. It comes out of common law. Way back, there's many different kinds of trespass. There's trespass to persons, there's trespass to property. It's pretty much where our laws come from. You have the right not to be trespassed against. Assault and battery, that's a trespass. Breaking and entering, that's a trespass. False imprisonment, that's a trespass. Acting in an authority position without the authority of law, that's a trespass. And it creates a, wherever we're at, not voidable, but simply void. Okay, so a party affected by void judicial action need not appeal. It is entitled to no respect whatsoever because it does not affect, impair, or create legal rights. When a rule providing for relief from void judgment is applicable, relief is not discretionary manner, but is mandatory. Alright, it appears Montana law follows this rule. Relief from judgment or order. B. Grounds for relief from a final judgment, order, or proceeding on motion and just terms. The court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons. Fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by an opposing party. The judgment is void. The judgment has been satisfied, released, or discharged. It is based on earlier judgment that has been reversed or vacated, or applying it's prospectively no longer equitable, or any other reason that justifies relief. Alright, now the next case I'm going to discuss is a 1950s case, State ex rel. Moser versus District Court. This case is actually the precedence for many judicial conflicts of interest that deal with judges. And in this case, it states, when a trial judge has been disqualified in a particular case by an affidavit of prejudice by a litigant. All right, in this case, we never got to file the affidavit of prejudice. We claim verbal motion and judge and prosecutor went running. Ideally, in the eyes of the law, they should have said file an affidavit of prejudice with the Montana Supreme Court, so the Montana Supreme Court could essentially supervisory control over the lower court to make sure that they weren't acting outside of their jurisdiction, and that everything that has happened up to that point follows due process of law to a so that way the state can get a proper criminal indictment against you. Alright, so prejudice by a litigant. His jurisdiction in the premises is taken away, and he can exercise only those powers expressly reserved to him by statute, namely arrangement of the calendar, regulate the order of business, power to transfer the cause to another court, or call in another judge. Now in Montana, power to transfer the cause to another court would be transferring it to Montana Supreme Court for them to look over and appoint another judge. All right, and then it's got some legal mumbo jumbo there, some citations. All right, so whereas in the instant matter, a trial judge on his own motion called in another judge, and this is what the Mosier case was about, called in another judge, neither constitutional nor statutory provisions enumerate any powers reserved by the judge who issues the call. But in analogy and by necessity, we think that there could be no more power left in the judge who makes the call voluntarily in the one case than if he were deprived of jurisdiction by the filing of an affidavit of prejudice. Okay, now like I said, there was no affidavit of prejudice filed, but Jeffrey Langton was deprived of jurisdiction, and that shows in the minutes by his own actions, as he was not even willing to set the calendar. And that is where his powers were diminished to. All right, criticism of a court's ruling or decision is not improper and may not be restricted after the cause has finally been disposed of and has ceased to be pending. That's applicable in this case because I discharged from these unlawful restraints several years ago. I don't feel this court needs a review from the likes of me when it comes to fundamental common laws. So my conclusion on the matter, although no formal affidavit was submitted to the Supreme Court of Montana as required by law 31805, and all motions are contained in the minute entry and records of my cases, I contend that Judge Jeffrey H. Langton's impartiality is reasonably in question. In DJ 9201, Langton was not disqualified by his own hand. He ignored his public duty to disclose conflicts until he was called out by the defense. This happened only after the closing of the first case and the opening of the second case. Many years later, Judge H. Langton assumed jurisdiction of the petitioner on his own accord in DCO 211 and DCO 854, and adjudicated these issues after his known disqualification for conflict of interest. Therefore, it appears Jeffrey H. Langton acted purposely and knowingly to deprive the petitioner of rights paramount to the integrity of the judicial system, or integrity of our judicial system, the right to a fair and impartial tribunal. In accordance with the spirit of Mosier versus District Court, Judge Langton was by all means disqualified, not by his own hand, moreover by impropriety of his own actions. That's, he didn't disclose his conflict, he waited until it was called out. That is not a very, that's not something that a man with real good integrity would do. Okay. Therefore, his jurisdiction of the premises is taken away, and he can only exercise those powers expressly reserved to him by statute. Because of these judgments appearing void on its face, the petitioner is in immediate fear of losing quality time with his child. Petitioner currently enjoys 50% parental rights of his child. The guardian ad litem's opinion can take that away. Petitioner's right to raise his child. Petitioner and petitioner's family deserve assurance that the guardian ad litem's opinions won't be fouled by fruits of the poisonous tree. Okay, now these are my legal questions. First question, and they're shoo-in, man. In cases involving the state of Montana prosecuting a child with disabilities, if the deputy county attorney that filed the petition and the judge that assumed jurisdiction over the matter are both immediately disqualified by a verbal motion, does that raise a reasonable question of impropriety? Question 2. Does a judge assuming jurisdiction in a criminal matter over an individual after his jurisdiction was lost to an unknown verbal motion that disqualified him 8 years previous raise a reasonable question of impropriety? Question 3. Do Judge Langton's failure to disclose conflicts as duty requires raise a reasonable question of impropriety? Question 4. Does Judge Langton's appeared failure to report his disqualification to Montana Supreme Court, as MCA 13805 seems to require, raise a reasonable question of impropriety? And number 5. Does a disqualification of a judge become void when a child becomes an adult because his parents are no longer allowed to use their conflict to aid in the petitioner's defense? Relief requested. In the interest of justice, I would like my rights restored and this abomination of unconstitutional record removed from my life. This includes any other remedy available by law. Thank you for your consideration. And then just some legal mumbo jumbo with my signature on it. So that is what I filed. That is pending in the Montana Supreme Court. I imagine they are going to want to settle outside of trial. If they are even willing to acknowledge this. If they're not, my next step obviously is to the federal government to file criminal charges, civil rights complaints, and civil rights issues. So yeah, this is what's been, hampering my life for the past 30 years. I've done, I spent 15 years of my life behind bars. I've been harassed by every means possible within the state. I've filed cease and desist orders against them. I've filed allegations against them inside the system, which failed. If you Google my name, Sean Ryan Cowan, you will find a litany of cases I attempted to have brought into the federal courts with no idea of what I was doing, and all were dismissed. But regardless, I have created a very substantial record inside the courts. So, now it comes down to whether Montana is going to acknowledge the criminal acts that their judges, well, in this case, singular judge at the moment, I can't say other judges, as well as, various other legal officials that are supposed to be, agents of the principal and not principal of the agents. So yeah, all this, raising my baby boy, trying to figure out how to fight this on my own has pretty much diminished me from any kind of shop activities. On top of that, I've moved my shop, which, that was a year worth of just trying to reorganize pretty much. Any of you guys know how that goes. Seems like even every project I do involves mass reorganization. So unfortunately, I haven't been able to post videos. I haven't been able to build my YouTube subscriber base. Apologize about that, guys. Hopefully, someday down the road all this will get settled and I'll be able to, spend my time playing in the shop as opposed to spending my time reading the law and attempting to hold the legal officials accountable for their violations of our laws. Hopefully, this has to do with all of us. This is my case, but it's all of our civil rights. If I don't stand up for these civil rights, they're just going to walk over the next person in the same way. So, if you guys want to show me your support, I'd appreciate it if you, put this out there on the internet, have people see it. Hopefully it's not overtaxing and overburdening. you're more than welcome to contact me through my Facebook page, or not my Facebook, I don't even get on Facebook anymore. My YouTube page. Ask any questions. I will try to present any evidence you want to see if you're interested. But you know what? It's time for all of us to band together. Now, with the power of the internet, we have the power to expose corruption for what it is. There's no more reason we should bow to our servants of the union, or there are no more reason that we should cower in fear of our servants of the union. The framers of the Constitution had it right, buddy. But I mean, it really depends on all of us to stand together, or we're going to be selected as individuals and persecuted as individuals. And as an individual, let me tell you, there is nothing you can do about this. I mean, these are like the most fundamental constitutional rights. And granted, I had a disability. It's my disability is in fine motor skills. It affects reading and writing and speech. And after 40 years, I've been able to teach myself to do this. I failed every grade in school up until college at 30, and then I actually passed a grade, which I was paying for, so there was a very good motivational factor for me to do my best. But I mean, this is abuse of children within our United States. I mean, this stuff happened to me when I was a kid. I was taken into illegal state care. If you Google Pine Hill School letter, you'll find a letter from the U.S. Department of Justice stating that the place the state sent me, well, they're not stating that the place, this is a correctional facility that I was sent to a short time after the Department of Justice pretty much found it unconstitutional on every fucking level to have a child in that kind of system. And then the state illegally prosecutes me less than a year later and stuffs me into that system. And then they continue to illegally prosecute me into adulthood using the same judge and the same void actions that judge created when I was a juvenile to enhance sentencing and show just cause, to implement fear in society because this person was out there. Okay, well, what I was busted for was kidnapping. It's actually quite a crooked story. I don't want to go into a whole lot of detail right now. I was victim of a theft. I filed a police report. The cop came by, told me to take matters into my own hands, gave me names of people to start my investigation with. Obviously, it took me a couple of months to put some resources together and to figure out who had victimized me. I wasn't 100% sure. So, since I was told to investigate it, I took investigative consent into my own head, quite literally. We ended up tying the guy's hands in a van and questioning him, which led to aggravated kidnapping. It doesn't help he went to the police and told like this big lavish story about us having a gun and dragging him behind the van and dragging him out of the casino, which was proved bullshit, yet the cops still decided to continue prosecuting. And essentially I was held in jail in front of a judge without authority to hold me in jail on an exuberant fucking bail and given a public pretender that couldn't pretend her way out of a wet paper bag to do this. Since this time I've gone through 12 public defenders. And it's funny because, that's 12 public defenders that have been appointed to represent a person who is not even in the legal system legally. So that's a lot of waste of money. On top of this, when I started questioning this about 10 years ago, these pricks attacked me and had me sent to the Montana State Mental Hospital, claiming I suffer from delusions of persecution and grandeur. Well, needless to say, State Mental Hospital ruled out the delusions, and they ruled out that I was malingering. So we had to get another evaluation, and that guy worked for the state prison. I told him to go fly a kite, to say it nicely, and he decided to read a bunch of my legal writings and write an opinion at the cost of almost $2,000 to the public. And then obviously that opinion couldn't be used because he didn't really get to evaluate me, so they had to have another guy come in and evaluate me at who knows how much money. And that guy, kind of went along with what the state was trying to say. And then we paid $4,000 for another evaluation who found me logical, rational, and non-psychotic. Although very angry because I perceive I have been abused by our system. Problem is my perceptions are based off of black and white documents, which the state purposely decided to ignore, and decided to bring in a psychologist of soft science to get to the bottom of it, when we don't really need soft science because it's all right there on the record. So yeah, I'm a bit frustrated. I've been considering, I don't have any money. I mean, I'm down to $100 or less than $100 to survive off of. I've had to take 3 weeks off of work to fight this. I haven't paid rent this last month. I'm pretty much about to lose everything again because I've already lost everything because we allow some drunk judge to continue to produce illegal documents. So that's where I'm at. I am sorry I haven't been able to get out in the shop and play. I will probably do another video right after this one. Just a little shop walkthrough. Show you guys where I'm at now. And hopefully sometime in the near future this shit will be over and I'll be able to spend some money on actually building some things instead of spending money on fighting an unjust government. And I mean, I'm not just talking unjust. I mean, so when a judge, and consider this from, an objective point of view, but when a judge does not have power to assert the authority of law over you, then that judge is acting in a criminal representation of what he believes the law should be. I mean, essentially, this judge, instead of acknowledging that I have rights, he decided to throw my rights in the toilet. He took his fancy little fucking hand and signed a piece of paper, and that piece of paper had the power to cause the entire judicial government of Montana to attack me for years and years. So yes, I am not very, I have a lot of anxiety when it comes to, dealing with people, dealing with the public. That's why I prefer to be more myself in my shop. This doesn't always happen. A lot of times we're forced outside of our comfort zones. Most likely because that is what we need. You need to get out of your comfort zone to be able to grow. I'm not saying that this is the way I would like to grow. But then again, we're all dealt a certain hand of cards, and just trying to make the best out of what we were dealt is really all you can do sometimes. I've done that for the past 30 years. I've tried to make the best out of what I was dealt. But you know what? It's come down to the point where the state wants to use these judgments to determine whether I'm a fit parent for my child. And, being as I was, according to documents that are here in my own control, as well as been submitted to the governmental authorities, wow, I forgot where I was going with that. Yeah, either way. So that's where I'm at. That's where I've been. My boy's doing great. He's huge. My shop's doing good. Somehow I keep on coming upon tools. I think I got 4 lathes and 5 mills out there right now. So it's a bad habit is what it is. But you know what? Until later, guys, I wish you guys all the best. I hope you guys make something cool. I hope you guys fight the good fights that need fought. And, I hope you win. And I hope any hardships that you guys are having out there are You know, they're all manageable. Simple as that. They're all manageable. Um, Tomorrow might look as grievous as today from where I'm standing today, but you know, I really don't know what tomorrow is going to bring. Um, you know, I don't want to be a fool who wastes 40 years of my life trying to fight a corrupt government, but I've already wasted 30 years of my life not trying to fight them. So, you know, I'm 40 years old now. Um, you know what? By the time I'm 80, I want to accomplish something in my life, and if that involves uh, defacing a government for criminal activity, you know what? I suppose that's an acceptable thing to accomplish in my life. Even though it's not necessarily what I want to accomplish. You know what? It's going to leave something better for future generations. And that's really what it's all about, man. We got to take care of our kids and we got to take care of their kids. You know, and as we grow up, and that is part of being a responsible adult in society, is as we grow up, it is our responsibility to correct issues and correct things that have happened to us and to pave the road for future generations to hopefully be able to live more prosperous, freer, and you know, and it's yeah, you guys know where I'm going. I mean, you know, shit like this shouldn't happen. I mean, this has happened for so damn long that if I would have flipped out and got a gun and started shooting at somebody, you know what? They would have said, "Oh, well, he's got a criminal record." But the fact is that criminal record was all created illegally. So, you know, I mean, where am I at? Where has the government pushed me to? I mean, sending me to the state hospital, sending me to Warm Springs, saying I suffer from delusions, while this judge is sitting in front of me and knows that he has no authority to be there. That is a fucking act of terrorism. That is domestic terrorism as defined by the United States fucking, the U.S. code. It would be under 2331 if you'd like to look that up. That is an act of terrorism, and you know, nobody should be submitted to that. So, you know, all I ask is you guys ain't even gotta like this, man. Just share it so my story can get out there. Maybe a lawyer will see this that can help. Um, you know, maybe an angel supporter will see this that'll, you know, send me a couple $100 so I can freaking pay my bills. Um, you know, but the money and the help doesn't matter. You know, just get the word out there that, you know what, once a judge is disqualified, a judge is fucking disqualified. Simple as that, man. Why? Because you have the right to a fair fucking hearing. I don't give a shit if you are a criminal or not. You have the right to a fair fucking hearing. You know, we're submitted to criminal acts of law enforcement every day without fair fucking hearings. So the least you could do is if they submit you to any kind of criminal allegations, learn your rights. There's plenty of information on the interweb. One of the biggest thing is jurisdiction. Learn where the jurisdiction of those pricks comes from, because 90% of the time they don't have it. But please share this and you know, support the cause, man. Support the cause. We all have to live together in peace and unity, and that's really hard to do when some of us are singled out and attacked by the systems. By by the individuals receiving assistance from taxes in order to protect us. Who will guard the guards?